Hi, I'm Seibel. I'm a judge in Stevens County in the 8th Judicial District. I've been a judge for 22 years, handling CHIPS cases during that entire period of time. I'm also the CGI lead judge for the 8th District. I'm here today to talk about one of the tools that is available to us that sometimes isn't utilized maybe as much as it should be, as far as disposition and trying to find ways to reduce the level of foster care reentry that we have in Minnesota. Minnesota has got an undesirable ranking. We're the worst state as far as children re-entering foster care, and we're trying to take some steps to develop ways to try to fix that, not for statistical purposes, but for the welfare of the kids. One of the tools that can be utilized is the issue of trial home visits. And over the years, as things have changed, I've noticed that some confusion maybe has developed relating to the issue of what is a trial home visit. And there's sort of a parallel disposition, protective supervision. So we want to sort of draw some distinctions between the two. With a trial home visit, the county agency retains custody of the child, and it is one of the allowable dispositions to allow a county to place a child back in the custodial home without the need to give up custody. They still maintain all the benefits of being the custodian and being able to be involved in the gathering information on medical and educational records. With a protective supervision, the custody is returned to the parent, and there are different requirements that are involved as far as protective supervision is concerned. A true trial home visit only occurs if the child is returned to the care of the parent who had custody at the time. So if you have a home where the two parents don't live there and dad had custody and they take the child away, a true trial home visit only involves returning custody to dad. If you return custody to mom, it's a different animal. And it falls more under the issue then, potentially, of protective supervision. Protective supervision allows the child to be in the custody of either parent. And again, that's one key distinction. Trial home visit, the county retains custody. Protective supervision, the parent has custody. Another big issue then involves what happens if that placement with the parent doesn't work. The benefit of a trial home visit is that the county can take the child out of the trial home visit, terminate the trial home visit without court order. If it's protective supervision, the custody being with the parent, you have to go through the regular EPC process. In other words, you need a court order. That's the other benefit. It used to be that under a trial home visit, it told all the permanency timelines. That's no longer the case. The permanency timelines are not told because the child still is in the custody of the agency. Now, with respect to the issue of protective supervision, the return to the custodial parent will toll the permanency timelines. If the child is placed in the care of the non-custodial parent under protective supervision, the permanency timelines are not told because permanency timelines are based upon return to the custodial parent. So that's a distinction that you should keep in mind. Something that sometimes I've found happens if you have a child that is in a trial home visit and the county terminates the trial home visit before or without a court order, the statute requires the county to notify the court and the parties within 3 days of the termination. That sometimes doesn't happen depending upon the agency. It's also required by statute that the county prepare a report for the court relating to why the trial home visit was terminated, whether it was by agency or by court order, and provides the opportunity for the court to issue an order to put into place other appropriate guidelines or procedures to ensure the safety and protection of the child. Perhaps the main reason that trial home visits should be explored more is it's sort of like a laboratory. And I can't think of anything better when we have a case plan in place and we're trying to develop skills in the parent or assist the parent with certain issues, to allow them then to put into practice the things that we're trying to have them learn. That way you can see if the services that you've been providing have been effective, and it probably, as I indicated, is the ultimate reasonable efforts. And so it's something that we try to encourage as an additional option for you to consider during the course of the case plan. Now, something in particular for our judges, the judges, in essence, sort of have to be the leaders in terms of addressing this issue relating to reentry of children in foster care. One of the ways that we can do that is to ensure that children are returned home only when they are both physically and emotionally safe, based upon the case plan and the feedback that you get not only from the parents and from the service providers, but also by the children and their reactions to their placement. Secondly, you should look at the case plan and focus not only on the services that have been provided, but also focus upon what are those services doing or demonstrating regarding what the child or the parent is able to learn and put into practice. That's the benefit of the trial home visit. It's also very important. Minnesota data indicates that if the first 100 days is the most important relating to re-entry into the foster care system. So if you are able to ensure that a child is able to stay out for at least 100 days, our prospects for success are increased. And so in utilizing a trial home visit, you may want to keep that in mind and see if you can keep that in place for that period of time. So again, we hope that you can utilize this as a tool to benefit kids, to benefit their families, and to reduce the incidence of re-entry into foster care that is causing our difficulties. Thank you.